Welcome to Small Practice Support Information Session number 58. In this recording, Richard Grogan provides an update on return to work in conversation with Justin Purcell.
We're just getting started. You're very welcome. This is Information Session 57. We're here with Richard Grogan on return to the workplace issues. So, Richard, you're very welcome. A hearty congratulations. And Rosemary Hayden says congratulations on becoming Employment Lawyer of the Year and starring in the Examiner today. So you're very welcome, everybody. And if you would like to ask Richard a question anytime on the chat, we'll take it now.
Yeah, delighted to do that.
So, Richard, over to you. There's a lot of issues at the moment with regards to return to work. There's a new safety protocol from the government. There's some advices. There's employment issues or employer issues, employment issues, and other stakeholders and factors. What do you think?
All right. Well, we'll deal with the first thing first, which is people coming back into the workplace. So at the first thing that you're going to have is that there's some people who are going to want to work remotely. So I'm going to deal with the remote working and the issues that that's going to have, because that's a significant issue for a lot of practices and for their clients when they're advising them. So people have been working at the kitchen table, and I had one case where somebody was working at an ironing board. So they're not acceptable any longer. So they have to have a proper workstation if they're working from home. So what does that mean? It means a proper desk, a proper chair. It's not just a laptop, by the way. If you're giving them if there's a laptop that they have at home, you have to give them a riser that brings it up to eye level, right? And you have to have a separate console for them to type on. And you say, but sure, it's on the laptop. Yeah, that's not good enough. It has to be separate, because otherwise they can hurt their arms, things like that. And then they're in for the PI claims. But you're also going to need probably a printer and a scanner, and you're definitely going to need a shredder if you're giving them a printer. And that all costs. But the problem on it is it's a one-off cost to you to get it done right, but you can only write that off over 7 years. Now, on top of that, you're going to have to do a health and safety assessment of wherever they're going to work. That can be done. It costs about 150 euro to get these done at the moment. They can be done remotely. You're going to have to look at GDPR. So if somebody is sharing a property, and you're doing, we'd say, something that relates to, a confidential issue, like you had a sexual harassment case or something like that. You don't want somebody looking in at their laptop or their computer. So that's a GDPR, huge issue there. And then you have the issues of light and heat and insurance. Now, who pays for the insurance if the person has an accident in their own home while working in their bedroom, when the ceiling falls in on top of them? So I'm just saying, these are the issues that have to be looked at, and there's a lot of work and a lot of expense to have somebody working from home. So you've decided, let's put it this way, that people aren't going to be working from home. Well, think again. You have to look at people who've got a disability, who might be immune compromised, or who have childcare issues. And there's been a decision recently by the WRC on this, where the person brought an unfair dismissal case because they weren't allowed to work remotely. They brought the wrong claim. It should have been an equality claim, but they self-represented, but they got 10 grand. So not something that you really want to do. So you have to be very careful on saying no, right? So let's deal with walking in the front door and what you shouldn't do. Now, some people are actually doing this, and welcome to a lot of pain, because this is going down to not down to the WRC. This could be going to the circuit court. Are you vaccinated? What? Are you vaccinated? I need to know. Only vaccinated people, I'm only having vaccinated employees back into the workplace. I need to know whether you're vaccinated or not, if you're ticking it off. Can't ask that. No. So you're doing your health and safety assessment. Now, one colleague got onto me and he had a great plan. And by the way, it was a great plan, out of the mouths of babes, sometimes you get pearls. And his thing was that he had about 12 employees between solicitors and office staff. And what he said was, he invited them all out for dinner 2 weeks ago, indoors. And he said, so they had to produce, on their mobile phone, their little certificate. So he came back and said, so now I know that everybody's vaccinated. And I said, and how have you recorded that? Well, I'm going to put it into the health and safety assessment. And I said, well, you can't put it into the health and safety assessment. The fact that you know that everybody is vaccinated, you can't retain that record. So what have I got to do? He said, well, you've got to actually write your health and safety assessment as if nobody's vaccinated. So that's a problem. And that's a real problem. Now, by the way, if you're taking on new staff, you can ask them, you can put it with a sign that says, no non-vaxxed need apply unless you've got a disability that you can't be vaccinated. And there's nothing they can do about it. It's only existing staff that you can't ask, but you can ask. So even if everybody's talking about it in the office and you know who's vaccinated and who isn't vaccinated, you still can't ask and can't record. So you've got that's a problem. So I know somebody's looking to ask a question, but I'm going to give one thing that is going to be a nightmare. So God forbid anybody has an outbreak in their office, but let's say they have, and you've got 10 people in the office and they're all milling around. And one person, well, let's say there's 11, one person comes down with COVID, and you identify all 10 being close contacts, right? Now, your health and safety assessment document should not really have that situation in place, but let's say they all are. And you're working on the basis that 90% of the people are vaccinated in reality. So if they're vaccinated, you say, if you're vaccinated and you have no symptoms, you're allowed to stay in the workplace. But if you're not vaccinated, whether you have symptoms or not, you have to go home and self-isolate. Or you have to go home for 10 days and come back after 10 days if you've got a negative PCR, otherwise you have to wait 14 days. Now, how do you record that? You can't ask anybody whether they're vaccinated. You can just say this. So they all walk out. We're going home. Well, you can't check it, you know? They all go home on Thursday. And on Monday, one of them phones you up and says, by the way, do you know what? I forgot I was vaccinated. I'll be back in. Yeah. You know, I was from Mayo. I needed to go up for the final. Forgot about that. Yeah. That's a problem. The difficulty on it is, in a lot of smaller offices, you're going to know who's vaccinated and not vaccinated. Somebody just sits there. Now, that's the problem, because you're not supposed to know. So you can't say to Mary or Michael, I know you're not vaccinated, out. Can't do that. So you got a problem. So what happens if you say, well, look, everybody is potentially a close contact. What I'm going to do is I'm going to send everybody home. And I'm going to require a negative PCR, and I'll pay for it. It costs about 120. You get that in a couple of days' time, like 5 or 6 days' time. Right, you have to pay them because they're allowed to stay in the workplace. So, on Taoiseach and the Taoiseach both told us that under no circumstance could you ask information about vaccination. It was in the original return to work protocol. But then the Data Protection Commission came out and said, oh, you can't ask questions like that. So we're going back into a workplace where you may know everybody's vaccinated or you may know who's not vaccinated. If something happens, you've got to effectively work on the basis that nobody's vaccinated. And if you send people home who are vaccinated, they can sue you under Section 5 of the Payment of Wages Act, because it's your decision to send them home. They were entitled to stay. And they bring you to the Workplace Relations Commission. You say, I couldn't ask them. And they go, that's not my problem. I was entitled to stay. You sent me home, so I'm entitled to be paid. And the person who isn't vaccinated, who you know isn't vaccinated, turns around and says, I was sent home too and I want to be paid. That was your decision. I could have been vaccinated. And the adjudication officer says, are you vaccinated? And they go, that's personal information.
Richard, you know the way you can't ask, but if I tell you willingly, what how's that treated?
Oh, well, now, Justin, that's a good one. Now, that's a great one now. Yeah, if you tell me willingly, right? Right. That's like throwing a drowning person a rope and giving them a choice whether they want to catch hold of it or not. The willing bit, the Data Protection Commission came out with, and they covered that very clearly. The employer is in a dominant position, and therefore any kind of request in any kind of shape, form, or description, or effectively encouragement, no, can't be done. And if you do it, you can be down in the circuit court for a breach of the data protection legislation for retaining information. Because if they tell you, it's of no use to you. The data protection is recording it. So if you record that everybody has told me that they're vaccinated, and you write your health and safety on that basis, or if somebody gets COVID, keep them in the office or send them home on that basis, you've recorded the information somewhere, and you said, well, I kept it at the back of my head. Yeah, no. You're then into a breach, because you've now disclosed private information relating to the medical position of various people to other people. So if you and I were in the same workplace and you're vaccinated, and let's say I'm not, and I'm sent home and you're not, there's a disclosure. So I know your vaccination status, you know mine, even though we might have been the two that would have been shouting at each other across the table on it. It's been disclosed by the employer. Now, by the way, this is a complete and utter shambles of the first order. I mean, it's a Pontius Pilate by the government. They've washed their hands of any responsibility in relation to this by saying, oh, you can't ask this question. So that's a significant problem that is there in the practicalities of operating a solicitor's office or any business or anything that's indoors. So at the moment, you're probably going to have to work on a meter apart is what they're going to probably come out with. And my advice is, if anybody gets off their chair, then in those circumstances, it's masks. Nobody into the office without a mask, but you can certainly check people coming into the office. Have they been vaccinated? There's nothing to stop you saying, I'm not allowing anybody into my office who hasn't been vaccinated unless they've got a disability that they can't be vaccinated, or I'm not letting anybody in without a mask. And if they say, well, I can't wear a mask, then you say, well, they can do Zoom or Microsoft Teams. Or they can stand on the stairs outside of the road outside to sign the documentation. You're entitled to do that.
Richard, though, there seems to be a paradox here, because if I go to a restaurant, they're perfectly entitled to ask me to prove that I've been vaccinated to allow me in the door. Why is the same not in place in a workplace? And I'm not trying to be funny, but...
Because the government said they don't want to be interfering with your rights to personal information. You don't have to go to the fancy restaurant or the pizza parlor. It's a choice. You do have to go to work. So that's the issue. So that's basically the issue on this. Is I was asked recently, a person phoned me and for an article that they're writing, and they said, would I have any advice to employers as to how they deal with this problem? And I said, well, you know, if you come from the Catholic faith, probably do novena and pray for divine inspiration. But until we get a return to work protocol, which, by the way, the last one could be used until it was ended up being torpedoed. The new one is going to be advice. Here's a few good ideas. A bit like restaurant guides in the Irish Times on a Saturday. You don't actually have to go there. It's all going to be down to personal responsibility. Or book passing is actually the better phrase. So it's going to be paddle your own canoe and hope for the best. But the litigation is going to be coming. And it's going to be coming from those who are vaccinated, who don't want to work beside a non-vaxxed. The non-vaxxed who don't want to give you the information. And try to put the health and safety in place so that you can actually work an office in a way that actually works. And then you're going to have health and safety complaints in. And if you get a health and safety complaint in, my advice is that you listen very quietly and say, thank you, I'll consider that. And then phone a friend, phone a colleague. How do I answer this? Because do not turn around and put anybody under a detriment. Because if you do, you're down to a claim in the WRC and maybe the Labour Court. So you have to be very careful. So that's the positive.
So Richard, a question there, sorry, about the vaccinations and appointments during work hours. How do you treat that information again?
Well, now that's okay because you're treating that for payroll, and provided you're only using the information for payroll. So if somebody's getting vaccinated during that time, you're entitled to say, well, I'm going to give you paid time off. But to get it, you can't be just, Skyping off for the afternoon. So you show me the vaccination cert that you got it done. You can't retain a copy. You just look at it and say, oh, that's fine, and tell payroll, yeah, you can pay Mary or you can pay Michael for that. But don't pay John or Joanna, because yet I'm still waiting for they'd have to get clearance yet,
So what sort of practical advices do you have for people or employers around all of these tricky issues around vaccinated, non-vaccinated, declarations, non-declarations, holding of information? Like you said, phone a friend, but...
Right, well, phone a lawyer. Yeah, if you're a lawyer, phone another lawyer. All right. I don't mean to be facetious, but at the present time, nobody's got a clue. Literally nobody's got a clue. And we're waiting for this wonderful, this announcement was made. We're coming back to the workplace on the 20th, right? We got the roadmap was there. We just got no directions. If you like somebody visiting Ireland for the first time and landing in Cork Airport and being asked that they're going to Buncrana and getting in the car and being told, we're going to Buncrana. How do we get there? Well, you take the road to Buncrana. Yeah, that's what we've got. So we're waiting to see what happens. What it's going to be is going to be a cop-out, and it's all going to be full of personal responsibility. So if you're an employer solicitor, my advice is going to be 1 meter apart, mask wearing, assume nobody is vaccinated, even if they've told you they're vaccinated. And you have to work through on that. That means cleaning down desks, cleaning the place, photocopiers and printers and the rest, if anybody uses it, having wipes there, and actually operating as if you're nearly walking around in PCC, in the protective gear. You have to be just working it on that basis, because you have to keep the 1 meter apart. You have to keep the windows open. You have to have air coming in. You might have to look at a CO2 monitor in due course. But certainly you have to be very clear. If you see somebody walking around the office without a mask on, that you shout at them.
So it's like nearly a pre-vaccine regime when we were back in the office. That still exists, and that's how you should approach it.
That's exactly what they're going to do. I mean, because they're not going to give you regulations that you can actually rely on. Previously, you asked the question, then you did the health assessment, and you worked out whether a non-vaccination person could come in safely or not. And then you did either remote working or you had redeployment. Now, they didn't go past that if remote and redeployment didn't work. But at least you had a map as to what you did. Now they're going to have nothing. So this is going to be a nice little document that says absolutely nothing, and it's a problem. And we're all just effectively working around as if we're operating prior to the return to work protocol on where we are with a bit of health and safety legislation being looked at. It's a disaster. So, but now for lawyers, it's a very good disaster if you can keep your own office fine, because effectively every employee of every employer potentially has a claim against the employer. So whether they're vaccinated or not, it's we lost whiplash. Now we can have return to work. It'll be the new whiplash. It's that difficult. That's a good one, isn't it?
Richard, September 20th is the next sort of cutoff date for the return to work. So is the employer entitled to say, okay, September 20th, everyone back to work?
Yes. Now, other than two things. One, you have to be very careful if somebody has childcare issues. You have to take account of that because people are finding it difficult to get creches. You have to look at that, and you have to see, is it possible for them to work remotely? There's an issue there on equality, and definitely don't go firing them if you're going to be doing. And the other one is somebody with a disability, who has a recognised disability. So it has to be a disability that they can't, we say, get vaccinated, and therefore they're immune compromised. They can't come back into the office. You have to be careful on those. Other than that, so somebody says, well, what about my right to request remote working? Well, that was announced by the Taoiseach as well back in May or June with great fanfare as how it was going to work. Well, the answer on it is he hasn't brought out the legislation even in bill format yet. And I'm on the Employment Law Committee. We haven't seen anything. And we're not going to see something for a while. And then even when he brings it in, it's going to take 8 to 9 months to get the claim on in the WRC. So the answer will be, even if the legislation was in today, it would be, well, bring your claim to the WRC. But in the meantime, you're either in or you're not paid.
And just going back to that childcare issue you just mentioned earlier, like what happens with kids who are sent home to self-isolate? Is the employee entitled to take time off to look after the kids in that situation? Or is that
put up a post on LinkedIn on this today? You're always reading my LinkedIn posts. Well done, you're right up at it. All right, first one is some employers say, well, you can take holidays. No, you can't take holidays. It's child minding. Holidays are supposed to be for rest and relaxation. Now, people might say it is rest, but if a child has to be self-isolate at home, which means they're not allowed to go out playing football on the street or whatever, it's not rest and relaxation in that situation. So that's one. If they're sick, it's even less rest and relaxation. So taking holidays, if a person has over 20 days a year, the bit over the 20 can be taken in that, because it's not covered by the Working Time Act, but otherwise it is. The other one then is effectively it's unpaid time, but you do have to look at the issue of remote working as well in those situations. And that is, can they realistically work remotely? And it depends. If their job is that they're the receptionist, they're not going to be able to work remotely. If their job is that they're a conveyancing solicitor or something like that, they may very well be able to work remotely. But then you may have to be looking at, then you're going to have questions that you're going to have to be very careful about asking. Because if you ask about what age the child is, and they say, well, the child is 16, and you go, and does he or she have any symptoms? And you go, no. But sure, can't they go back to school? Sure, that's the rules on it. Oh, right, they're not vaccinated. Now you've asked questions that you shouldn't be asking. So you can't be asking those kind of questions. Or if you do ask them, you need to be very careful what the response is. They're 16 and they're not vaccinated. Yeah, not maybe the best answer to put in. Because if they're not vaccinated. But the one that I will say to you is, you have to then look at, is it possible to do it? And that's realistically possible, which means you still want them to work their 7.5 hours in the day, but it may be that they're going to have to work early in the morning and late in the evening, and then you have to be careful of the 11-hour rule and the rest. But if you've got a 6-year-old running around the house, a lot of people, it depends if they've been used to doing it. You're probably back to how they were operating before you went back into the office, but there's flexibility is needed on that. And again, the government has given us diddly squat as to how you deal with that, and there's 14,000 children at the moment having to self-isolate.
So you've brought me on nicely. If anyone would ask a question, we've got sort of 8 minutes left. So if anyone wants to send a question in the chat, we'd love to take it. Just that point that you made about treating people flexibly, and could this lead to a scenario where everybody's treated individually and individual arrangements are made for particular employees? Are you allowed to do that?
Yeah, you can, provided you don't discriminate. Now, this is the whole issue that's now coming up is, can you now start giving positive discrimination for people with children?
Or let's take the children out of it. Just you've decided to choose to allow me to do something and the other person not.
Well, again, you then have to be careful of the 9 grounds under the equality legislation. So now some of them won't apply, but you could have, we say, somebody who has a disability or who's immune compromised, and they tell you that, and you say, well, look, I'm actually going to allow you to work remotely all the time. And then you get somebody else coming in and saying, well, look, hold on a moment. So let's say it's a he that you allow go home. You get a female solicitor or female secretary comes in and says, you've discriminated against me because that person's a male. Now you have a situation that you've got very, personal information in relation to one person that you can't say to the person, look, I can't. No, it's because Joe is immune compromised. He's got this disability. You can't go telling them that. So you have to be very careful in relation to that. It is a good idea. You will have to. There is going to be individual ones. The one for working from home now that's going to be coming up, and you're going to see it is, if you want to work remotely, I don't mind where you're working from, but I can see very quickly salary increases coming in various places is going to be put down is we're not doing salary increases this year. We're doing a work from the office bonus payment. That's because people are going to want people in. Working remotely has worked very well for an awful lot of people. There's no doubt about that. And people like it. The information coming back is that while people were as productive, it was because they were working longer hours. So in fact, they were pedaling faster to get to the same speed. So there is issues in that, and there's huge issues with training and team building and all the rest that people need to be able to relate. And by the way, there's a thing that's coming up at the moment that it appears that the Botox clinics are out the door because people are looking at themselves on screens all the time and they're going, I'm not really, there's an awful lot of lines here. I better head down to the Botox clinic. Now, luckily, I have to wear glasses, so I can't really see myself most of the time. So that's the issue that's coming up. So there's a lot of issues there, and you have to be careful even of Zoom time, by the way, because be careful of people's eyesight. They're supposed to be sitting back a bit from the machine. I'm fairly well back from my machine, but that's.
So here's one for you, Richard. Two questions at one time. So when are employees on layoff entitled to claim redundancy? And then moving on from that, what are the classic unfair dismissal errors that an employer could possibly make? Is that fair to ask those two together?
Yeah, all right. 30th of September is when the employees can start claiming. And at that stage, they throw in on the 30th of September, I think saying, I've been on layoff for 4 weeks, right? The employer then has 7 days to give a counter notice. Now that's 7 days, that's not 7 working days. So if the employee throws it in on Friday, delivers it on Friday, on a Friday. By the way, it could be Friday of a bank holiday weekend. They deliver it in on Friday. You have until the following Friday to deliver an employee a counter. And if that counter isn't actually delivered, it's not phone up or text them, it's actually delivered. And that's a counter notice, which is within 4 weeks, you give them 13 weeks full-time work. If you don't give them 13 weeks full-time work within that period, they're entitled to claim the redundancy plus another 13 weeks wages. Have a nice day. Classic unfair dismissal, not following procedures. And the big one is you advise the person on what the issue is. You give them a right of representation by a fellow employee or union official. Don't tell me we're not unionized, we're a solicitor's firm. I'm just putting that in. Rubbish. They have to be advised of it. It's not that you're recognizing a union other than for that. They have to be given a right to cross-examine any witnesses. They have to have the person hearing the disciplinary can't be Judge Bean, complainant, witness, prosecutor, and hangman. Can't be that. They have to be given a right of appeal. You have to go through the processes, and it's the process, the code of practice and grievance and disciplinary procedures at a very minimum, or if there's a staff handbook that has procedures, you have to follow those. The big ones that happen, nobody reads staff handbooks, particularly not managers and owners, and they just fire somebody. And somebody like me or any employment law solicitor comes in and says, what about your procedures? The other big one that gets people caught on is gross misconduct. Everybody loves gross misconduct. I adore gross misconduct. And employment lawyers who do representation of employees love gross misconduct because you can't take into account anything that happened before. If you dismiss them for misconduct, you can take into account previous warnings. If it's gross misconduct, it's a standalone offence and it has to, on its own, warrant dismissal. So the fact that somebody's on their second written warning or a final written warning, then turn around and say that the next one is gross misconduct, forget about those. It has to stand alone. Don't do gross misconduct. The best you save is the minimum notice. That's all you save by doing gross misconduct, and you can end up in a lot more problems. Hope that answers that one.
Richard, we're just going up into the last sort of 2 minutes, so final questions. Does PUP is not part of the calculation of reckonable service for redundancy? Is that correct? So PUP not reckonable for?
Sorry, it's reckonable for service. Layoff is reckonable for service, not for calculating the.
Sorry, PUP is payment. Reckonable for service. Yes.
So if somebody was taken on let's say the September 1st of September 2019, and they're let go and they apply for redundancy on the 30th of September 2021, At that stage, they do have 2 years service. It's just for calculating the amount of payment. They would only be effectively from, let's say, the 1st of September to March 2020. But it counts for service, not for calculating the employment payment. So yeah, if you've been on the pub for 2 years, it all counts towards service.
Listen, Richard, you've been a good sport today. Thanks a million for answering all our questions. We've covered a wide range of issues, and you've been very open and amenable. So thank you very much. It's a real privilege to talk to you today. Congratulations again on being an Employer of the Year award, and we'll talk to you again soon. Next week up is your colleague Rory O'Donnell, who's going to give us an insight into the guide to easements, where there's some change in legislation regarding them. So we look forward to talking to you then. So Richard, Slán agus Gur Mágat, and guys, stay safe, and we'll talk to you next week.